Okay, good day to you all, and welcome to this session of Friends of Multilateralism Group. My name is Xiankun Lu. I'm the CEO of the group, and as you could see from the invitation, this session is called the Decoding Series of FMG. And we thanks a lot to Alejandro, our member and a former co-chair of FMG board, who has initiated this idea. And me and Gabrielle, we immediately like it, and Gabrielle kindly accepted the, how to say, imposition of this work to lead on this initiative and helping putting it together in a very quickly this panel, and then starting already the first session on this recently MPIA case ruling. Just one word to say is that, of course, we as the group of multilateralism, and we think that it's important to sustain the WTO, including its dispute settlement mechanism, through probably a different way after the blockage of the nomination of Appellate Body members. So this is a way to show that the WTO its dispute settlement is still alive and kicking in a different format. The second thing is, of course, is that the dispute cases and the rulings, all the kind of documents, everything is quite complicated and technical, not only to the public, but also to trade workers like us. So it will be good to have Gabrielle and other experts help to kind of decode what it is about and so on and so forth. The only thing we would not do, this is going to be factual, this only thing we will not do is not to touch upon on the kind of potential ways or means to implement the result of the ruling, because I think that's up to the parties to the dispute to decide and to negotiate and to do it. So with that, I thanks Alex and Gabrielle for leading this, and I will give floor back to Gabrielle. Thank you very much, Gabrielle, please.
Thank you, Lou and Alex. I'm not sure you can call me an expert in intellectual property. This would be a bit of a fraud, although I've done a lot of dispute. But we have, as mentioned, over, I think, 120 registration, and that's because we have outstanding panelists. 2 words on them, and then we'll plunge. The way we will proceed is the Jayashri Wattal, who was negotiating for India at the time of the TRIPS. She's now a teacher, professor at Georgetown, worked in the WTO for years and years. She will explain the main issues first. And then 2 top international experts in IP. First, Professor Cohen will intervene 10 minutes. It's difficult to introduce these people with outstanding CV. All I can say is that Professor Cohen has 40 years of private public sector in-house academic experience. The State Department, I thought this was quite particular, ranked him 4 on 4 on his speaking and reading of Chinese, and indeed he worked in several firms in China, and he got an award, the highest award for civil servant, recommended by the previous president, but given by President Trump. And then we will go to Professor Enrico Bonadio, who's professor of law at City St. George University, also an amazing background of research, publication. And one thing that impressed me is that he has taught, giving classes, etc., in over 150 universities all over the world, I suppose in many, many languages. So it's an amazing team. And I start right away in asking Jayashri a very simple question. You were there, Jayashri, during this TRIPS negotiation. Did you talk about these difficult concepts of SEP, Standard Essential Patent, and ASI, Anti-Suit Injunction? And could you explain these concepts, the commercial issues, where the panel and the MPIA diverge, but for people like me who are not IP expert? Please, Jayashri.
Jeffrey, you're muted.
Thank you, Gabrielle. And thank you also, FMG, for inviting me to be on this very interesting panel. Thank you especially to Lou and Gabrielle. So I'll plunge in straight away. And I assume everyone in the audience knows what a patent is broadly. But what I think is not very well understood is that there is no such thing as a global patent. Patents need to be applied for and granted in each jurisdiction, and they coexist independently through the principle of independence of patents, which is laid down in the Paris Convention, which dates back to the end of the 19th century, but was last revised in 1967. The big change brought about through the TRIPS agreement, of which, as Gabrielle said, I participated as India's representative, was that it obliges its members, as of today, except LDCs, all members are obliged to make available and enforce patents in their territories for eligible inventions and to grant patent owners the exclusive right to make, use, sell, import the patented invention for a period of 20 years from the date of filing of their patent applications. So this obligation, like most other TRIPS obligations, has to be implemented through domestic legislation. That's the way intellectual property works. Now let's turn to the term standards in the context of this case, because standards can mean different things to different people. The context of this case is the information and communications technology sector, ICT, and standards here provide a common language, the technical specifications that allow devices and systems made by different manufacturers to communicate and function together seamlessly. This is how our mobile phones work, for example, especially when we travel to different countries. Think about features like 3G, 4G, 5G technology and Bluetooth, Wi-Fi, etc. Such standards are voluntary unless mandated by national law or regulations. And at the international level, which we are most concerned with in this case, standards are usually set by standard-setting organizations such as the International Telecommunications Union in Geneva. And usually this is done with the active cooperation of industry, the key players in industry. So a standard is sometimes also developed independently by industry consortia, such as was done in the case of the USB, and these can become de facto mandatory just through wide-scale market adoption without any government intervention. So that's another thing that we need to know. If a particular standard requires the use of a patent-protected product or process that is included in the standard, then that patent is called a Standard Essential Patent, or SEP for short. Any producers implementing that standard in their product or implementers will need to obtain a license for using these patents or risk being sued for infringement. Potential holders of SEPs stand to gain a lot by getting their patented technology included in a standard, because this can provide them a captive market of very large volumes, potentially global markets, right? So SEP holders can also get significant market power over implementers of the standard because their patent has to be used, right? So there is a potential for the SEP holder to abuse that power, potential to abuse that power by demanding very high royalties. These are called, in the jargon, patent hold-ups. And it's for this reason that at the time of developing a standard, patent holders are required by the SSO, the standard setting organization, to declare upfront the existence of a patent and typically to commit to licensing on fair, reasonable, and non-discriminatory terms, or in short, FRAND terms. One problem in this area of SEPs is that there is no international body that determines FRAND terms on a global basis. Yet, SEP holders and implementers could and typically do amicably negotiate license terms, global license terms. But equally, it's not uncommon for them to disagree on license terms. And this leads to litigation, quite often in multiple jurisdictions, or what are called parallel proceedings. Courts are often called upon to set FRAND terms, and sometimes they do so on a global basis, or to issue exclusionary orders that prevent the sale of a product in a particular jurisdiction. Where implementers use SEPs, even without permission, SEP holders may seek arbitration to get the terms settled in a court, or they may sue for infringement of their patents and seek injunctions. Remember, patents are territorial, so the injunctions are sought for in the territory where the patent is valid. Implementers may defend themselves by alleging that the SEP holders are abusing their dominant position, this is a competition law concept, by not offering FRAND terms. Now, delaying proceedings by implementers as much as possible while continuing to infringe the SEPs with a view to obtaining lower royalty rates is called patent holdouts in the jargon, as against patent holdups, which SEP holders might utilize. So now let's turn to what an anti-suit injunction is. So in the context of SEP litigation, this is an in personam court order where a litigant is ordered by the court to take or refrain from taking certain action with respect to litigation in other jurisdictions, obviously involving the same patented technologies and the same or related parties. This is in parallel proceedings. In SEP litigation, ASIs, that is anti-suit injunctions, are predominantly requested by implementers and not SEP holders. The use of ASIs to prevent parallel litigation has also led to retaliatory or anticipatory measures known as anti-suit injunctions, which are of course requested by SEP holders to prevent an implementer from seeking or enforcing ASIs. So it's a bit complicated because technically or theoretically you can go to triple ASIs, anti-suit injunctions, though it hasn't really happened. So in the mobile phone area, monetary stakes are pretty high. This is why this is so important. This litigation game, which is played by both sides in multiple major markets and increasingly also in emerging markets, using a mix of patent law, contract law, and competition law. Many jurisdictions issue ASIs and AASIs in such SEP litigation. Eventually, almost always, the two parties settle on FRAND terms. Now let's go to the content of the European Union's complaint in the WTO. So the crux of the EU complaint is that China has an unwritten ASI policy that encourages domestic courts to issue ASIs where SEP holders are foreign entities and implementers are domestic manufacturers of the product in China. So the EU has argued that such a policy exists in China and has been used in 5 specific cases cited in their complaint, none of the final judicial decisions of which were published as is required under a TRIPS transparency obligation in Article 63. Moreover, EU alleges China violates the patent rights provision Another provision which gives the patent owner the right to license, assign, and so on, and yet another provision in the enforcement section on injunctions. And all of this, according to the EU, has to be read with Article 1.1 of TRIPS, which obliges members to give effect to the provisions of the TRIPS agreement. These words, give effect, according to the EU, includes not just the implementation of IP obligations via domestic legislation, but also a negative obligation to ensure that the implementation of the TRIPS obligations by other members, WTO members, is not frustrated. In short, an anti-frustration obligation. Further, China also violates the enforcement provisions, says the EU, because it creates barriers to legitimate trade. This is in Article 41 of TRIPS. So what does China say in its defense? China defended itself by stating there is no ASI policy, that the courts in China decide on ASIs on a case-by-case basis, as in other jurisdictions. None of the cases cited by the EU were of general application, and hence China had no obligation to publish them, that there is no legal basis to read any additional anti-frustration obligation into the TRIPS provisions, particularly in Article 1.1, and that ASIs are not enforcement procedures, and hence the enforcement provision, Article 41 of TRIPS, does not apply. What did the panel find? The panel found in favor of the EU on some issues. One, that there is an ASI policy in China. Two, that China did violate the transparency obligation in Article 63, but with respect only to one of the 5 court decisions, which it said was of general application. But on the other hand, it held that ASIs are not specific enforcement measures under TRIPS, and therefore Article 41 was not violated. However, and more importantly, it ruled against the EU and in favor of China to conclude that no anti-frustration obligation can be added on to the TRIPS provisions, onto Article 1.1 and the other TRIPS provisions. The EU appealed this panel decision to the MPIA. Both EU and China are parties to the MPIA. Mostly, EU reiterated its prior arguments, but it found particular fault with the panel for ruling that Article 1.1, the words give effect to, does not contain an anti-frustration obligation. China also appealed the panel decision, arguing there is no ASI policy and it did not violate the transparency obligations under TRIPS, mostly reiterating its prior arguments. Now, the MPIA upheld the panel decision on the existence of the ASI policy in China, on the violation by China of its transparency obligations as determined by the panel, and agreed that ASIs are not covered by TRIPS enforcement provisions. On the anti-frustration obligation, it reversed the panel finding by reasoning that a reading of the TRIPS agreement's main objectives, as included in Article 7 and the preamble, and in the light of several other TRIPS provisions on transparency and cooperation, any measure that frustrates other members' TRIPS obligations would be a violation of the object and purpose of the TRIPS agreement, and ruled that there is an anti-frustration obligation pursuant to Article 1.1. Now, I must say that I have said that anti-frustration, that's not a term used by the panel or the MPIA. So let me turn now to Gabrielle's question on whether any of this was discussed or in the TRIPS negotiations way back when we actually negotiated TRIPS, which most of it was done in 1989, 1990. It was almost all completed by the end of 1991. At that point, these issues were not live. There was no such thing as standard essential patents. All of this came in much later. And so TRIPS is silent on this because the negotiators never really considered these issues. So with this, let me hand the floor back to Gabrielle so that we can hear what is much more interesting, what my co-panelists have to say on this. Over to you, Gabrielle.
Thank you. Thank you, Jayashri, for this background. We took a bit more, 14 minutes, but it was too essential. So now I go to Mark. Mark, what are the differences in your view between the sort of arbitration MPIA decision and the prior panel and the outcome? Were they, in your view, properly decided? You're a great expert on transparency, but also this frustration or anti-frustration. What are your views, please?
Thank you very much, Gabrielle, and thank you, Jayashri, and my co-panelist, Enrico, for putting together this great program on a very interesting topic. I think an hour and a half will hardly do it justice. It's just so many aspects to it, not just the public international law and WTO aspects, the impact on the Chinese system, on foreign courts, on private international law, et cetera. As far as I know, our audience today includes individuals with these diverse backgrounds, experienced in WTO matters, experts in IP law and Chinese law, and presumably, I see some experts in SEPs and standards. So I hope that we can be a bit interdisciplinary, at least I will try to be, in combining these different perspectives. And I'll try to divide my comments into three baskets: transparency and TRIPS as it materializes in the panel decision and the MPIA decision. Frustration principle, as Jayashri is so well articulated, it seems to be a new part of the vocabulary, but I want to relate it back to the TRIPS agreement itself and what it might mean in the SEPs context. And thirdly, and I think very importantly, kind of how this case opens the door on other issues and how they might be resolved in the future. So let's begin with some background on transparency. The last prior major case involving transparency in China's IP system, as far as I know, was the US-China IP enforcement dispute, DS611. That was 2007. I'm a proud alumni of that case, representing the USPTO, and I noticed several people in the audience who are also veterans of it from inside the WTO and out. So I think it's useful that we're all following it. In my view, speaking personally, and these are all personal comments, the US decided wrongly not to pursue the non-publication of cases as a separate issue onto an appeal. It did not appeal. This was a very important issue at the early stages of China's WTO accession, and it still is not fully resolved even with the decision, the MPIA in the panel in DS611. Notwithstanding the handling of that case, and this probably to a certain extent shows the limitations of WTO decisions or the importance of adherence to the spirit of the WTO. Case publication in China has since improved dramatically. And I looked yesterday on the official judicial database, a free database, I might add. It has had 120 billion separate visits, 158 million documents in total, 97 million of which involve civil disputes. Those are big numbers, maybe the largest database, legal database in the world. IP cases were, in fact, the first cases to enjoy some degree of widespread publication in China. However, case publication, this does not appear in the decisions, has been declining. And even at its peak, China was only publishing about 50% of decided patent cases, and it's since declined from that. And only a small minority of these cases involve foreigners, so it's possible to publish all cases involving foreigners. And in recent years, case publication has become more curated in terms of what gets published, when it is published, and anonymization of cases. So we don't often know the full name of the case unless you happen to be familiar with the facts. The panel found that InterDigital versus Xiaomi was a case of general application within the meaning of Article 63 of the TRIPS agreement, and it was a reference for future cases. The case did not address what I've just indicated, which is the overarching importance of transparency, not only to China, but also to the TRIPS agreement, the global IP system, and to an understanding how China functions in that world with the largest active IP docket in the world, about 500,000 IP cases per year. And in areas, newly emerging technologies like AI, that's really important for other countries to know how China is handling the new challenges. The application of this case to other cases is, however, limited. According to the arbitrators, a case of general application will need to be determined based on the facts of each case. We're not going to do that with 500,000 Chinese cases. With respect to the Xiaomi case, the court noted that it was a top 10 provincial typical case and that it provided a useful practice for China to use ASIs in cross-border civil disputes. Nice language. Those standards could apply to many other cases. Importantly, it appears that neither the arbitrators nor the panel was looking only to what Chinese courts consider precedential or highly influential. China has a separate doctrine of what constitutes precedential cases. How this will affect other cases, including how it might affect classes of cases in this highly litigious environment, is yet unclear. To be blunt, the lack of transparency, in my view, arises as much from excess politicization as any other factor in Chinese judicial decision-making. This helps explain why a court in Hubei province can become a destination jurisdiction for ASIs, language from my own blog several years ago. Wuhan traditionally had relatively few IP cases compared to other jurisdictions, particularly patent cases and ASI cases. Moreover, the cases arose shortly after an important conference in January, which I happen to have attended, which discussed whether China should introduce ASIs. China was also consciously learning from the experience of other courts, and a decision was made, in the words of one prominent Chinese trial judge, that ASIs were the new, quote, battlefield, close quote, of international IP competition. So it seems to have been a political motivation. Curation or politicization of case decisions was also a part of the background for this case from the very beginning, although it's not discussed. The Lenovo versus Nokia case, where an ASI was not granted, was decided before consultation started and was published 1 month after consultations began. And it is not on the official judicial database, although it is on an important courts database. Moreover, once consultations initiated, China stopped issuing ASIs altogether, at least to judge from the incomplete databases. And there was one case where the Chinese courts importantly noted that they can make global rate determinations. Perhaps that's the lingering counter policy. So this case had some interesting consequences for the domestic environment, and I think globally, apart from the WTO context. And it's somewhat hard, in my view, to implement more broadly based on the limitations of what constitutes a case of general application. I'll next discuss the arbitrator's decision that ASIs frustrate other countries in the implementation of TRIPS obligations. The word frustrate, Jayashree may be interested in knowing, appears 39 times in the arbitral decision, about once every 2 pages. This is a lot. It's clearly a key point, even though it's not in the TRIPS agreement itself. Although the primary obligation is that every member needs to give effect to its TRIPS obligations, the arbitrators appeared to be more comfortable with the negative of not frustrating TRIPS obligations. Actually, I think a positive obligation could be a lot broader than a negative obligation of not frustrating. So I think that's an important distinction. A critical aspect would appear to be an assessment of whether the ASI would undermine the SEP holder's ability to exercise its exclusive rights conferred under Article 28 of TRIPS. This may be more difficult than it appears. The panel identified at least 5 factors that typically form the grounds on which ASIs are issued by Chinese courts. It did not consider that Chinese courts have traditionally avoided comedy-type analysis and have taken a protective stance over their own jurisdiction, showing reluctance to afford comedy to foreign courts. And this seems to be attributable to a principle of judicial sovereignty rather than mutual respect or deference. And Vivian Bath at the University of Sydney has written extensively on this, including on ASIs, and how China has really difficulties in grappling with comedy. What then would be an acceptable ASI that does not frustrate TRIPS obligations or an acceptable judicial decision? First on my list would be an ASI based on a choice of jurisdiction or agreement to arbitrate. As there's a predetermined choice, there's arguably no frustration. Second, it might be one that does not take effect until the issuing court has made its final decision. This seems to be the Lenovo versus Nokia case. Third might be an anti-interference ASI, which is when a second court issues an ASI against the primary court in which it does not authorize actions that undermine its own appropriate jurisdiction. A problem is that hardly resolve the questions of frustration affecting multiple WTO members. You can have independent patents, perhaps in multiple jurisdictions, including increasingly in the developing world, and one that's only directed to one court. Hearing a case may not be enough to address the problem, although it may help some. Fourth, another might involve the court deconflicting disputes. Do the two cases involve the same patents or claims? How identical? Same standards? Are they sufficiently different? Et cetera. And I've also written on this in an article that was just published in the European IP Review on different standards of FRAND. How will China comply with the arbitration order? Well, we'll have to see. And the vehicle could also be interesting, whether it's a judicial interpretation, a policy document, or even legislative change. The third issue is impact on the global system. DS611 has had an impact since the time the case was initiated. China, as I said before, has not issued an ASI since then. Second, DSI is also, 611 has also reopened what is perhaps the most significant issue in China's IP regime today, whether lack of adequate transparency hampers the ability to properly consider China's implementation of its TRIPS obligations, as well as our understanding of China's increasingly complex IP environment. For example, as I mentioned, China has about 500,000 IP cases in its courts each year, about 25 times the federal docket. How do we know that there weren't other ASI cases? How can we judge comparable licensing rates? There's a vast trove of information related to ASI specifically that could come out if there was full publication. There's a lot of people that have written on this during the first 10 years or so, from around 2013 to 2023. There were about 200 ASI cases, rather SEP cases, that were largely not published. So there's a vast trove of litigation information that's beyond the reach of outsiders due to a lack of comprehensive transparency. Frankly, I think that would also benefit China, so we could all understand its system better, and our criticisms would be more focused, or they might not exist at all. Transparency would improve confidence in Chinese courts and its IP system. Chinese authorities, for example, repeatedly note that foreigners have high win rates in the courts. This cannot be fully verified absent transparency. In conclusion, DS611 is one of the few TRIPS cases involving transparency, which is a core TRIPS obligation and fundamental to understanding China's IP environment. The case is therefore also extremely important in promoting rule of law. Expanding transparency would directly benefit China's own citizens and companies, as well as foreign companies. And this is particularly true in light of declining transparency in recent years. Sadly, the US submission to the panel did little to advance this importance of transparency and overall rule of law. The case is also important in demonstrating that WTO dispute resolution is capable of effecting change. And in economic terms, it's important because of the role of SEPs. China's role as a major licensee and increasingly as a major licensor, and the importance of parallel litigation in resolving SEP disputes. And I'm sure we'll be hearing about these types of issues in the future. Thank you.
Mark, we lost, or I lost your image. I don't know.
Okay.
Now I see you.
Yeah.
Good. It's easier to, even if it's only virtual, to see someone. So thank you very much. We go now to Enrico, who has published, I think we circulated 2 papers, well, one from Mark, one from Enrico. And my question to you is about this anti-frustration rule. That requires that member not frustrate the operation of the other member's IP enforcement system. Can you explain whether and how it affects the TRIPS agreement balance between this call for harmonization and national autonomy in IP law, and particularly regarding the flexibility in designing domestic intellectual property frameworks? And if you have the time, what's the difference between legitimate expectation, which is a concept that trade lawyers know, and this anti-frustration rule? Please, Enrico.
Thanks so much, Gabrielle Jayashri, for the invitation. Yes, I mean, my opinion is that this ruling may reshape the landscape of international IP enforcement through the creation of this controversial anti-frustration rule. It's true that the arbitrators have not used this term, as Professor Wattal said, but actually, de facto, they have probably introduced an anti-frustration standard, which is not explicitly present in TRIPS. So I think this decision challenges core principles of IP, territorial sovereignty, and may also have an impact on global licensing practices in SEPs litigation around the world. So first issue, erosion of territorial sovereignty. The interpretation of TRIPS Article 1.1 by the arbitrators has created inevitably an extraterritorial obligation that, in my opinion, may undermine the territorial foundation of patent law. By requiring that WTO countries must give effect to TRIPS without frustrating the functioning of the system of IP rights in other countries, the ruling effectively may convert what was traditionally understood as a domestic implementation provision into an instrument of judicial amendment. And this transformation, in my opinion, is particularly troubling because it contradicts the well-established principle of independence and territoriality of patents under Article 4bis of the Paris Convention, which, as we all know, is incorporated into TRIPS through Article 2.1. Yet, in my opinion, the arbitrators kind of failed to adequately and appropriately consider how this new anti-frustration standard undermines that Article 4bis of the Paris Convention. They just mentioned it once in the ruling in just 2-3 lines. In my opinion, they should have paid more careful attention to that. And more worryingly, the lack of limiting principles in the reasoning creates uncertainty for all WTO countries, because without clear boundaries, this anti-frustration test could evolve to restrict a wide range of legitimate domestic policy choices regarding IP enforcement, effectively creating a supranational IP enforcement regime that WTO countries never agreed to establish. Countries, in my opinion, may now face the prospect that any judicial or administrative act that tangentially affects foreign patent enforcement could be challenged under this new rule. So in other words, without clear boundaries, this new test, anti-frustration test, could evolve to restrict legitimate domestic policy choices, right? Also should be considered and remembered that incentives and opportunities for IP owners to sue abroad, including strategic concerns like forum shopping, are usually matter of private international law, not WTO law. So, also it has been said by some commentators that this approach may also violate the Dispute Settlement Understanding Article 3.2, which prohibits WTO adjudicators from adding to or diminishing rights and obligations under the WTO agreements. But let me move to the second issue, the impact on the global front licensing practices. Because as several of you might know, in the latest years, there is this trend by UK courts of, for example, establishing global front rates, even when the sales have occurred predominantly in foreign jurisdictions. The UK does so since Unwired Planet in 2000, the Supreme Court case. This approach creates, in my opinion, the same frustration effect that the arbitrators condemned in the Chinese anti-suit injunction case, by substituting basically UK legal and economic determinations for those of other jurisdictions. German courts have developed an equally problematic practice through an unwritten policy of issuing injunctions when standard implementers, standard users, request country-specific licenses rather than accepting global licensing arrangements. So, in short, you don't accept a global license, even when the sales are outside, predominantly outside you get an injunction in UK, you are expelled. You are shown the red card from the UK market, for the German market. The UPC, the Unified Patent Court, has adopted a similar approach in its early SEP decision last year. In Panasonic versus Oppo, the Mannheim local division dismissed Oppo's FRAND defense partly because Oppo, the implementer, resisted accepting a single worldwide global FRAND rate. But this global licensing approach, adopted explicitly by UK, suggested by Germany UPC, could now be under attack under the new anti-frustration rule. Why? Because as China anti-suit injunctions have been found to frustrate the patent owner's ability to exercise his exclusive rights under Article 28 TRIPS, likewise, global FRAND determination practices or pressures by courts of a country also frustrate the territorial sovereignty of other countries, of other patent adjudicators in other countries. And let's remember that we have another case, a complaint which has been filed a few months ago by the EU against China, exactly on global FRAND licensing practice by Chinese courts. Chinese courts are accused of establishing global FRAND rates which are lower than the global FRAND rates established by UK, but it's still a global, it is still a global FRAND license. And there is this action started by the EU, which is a bit ironic for me, because German courts, and Germany is part of the EU, use FRAND global licensing approaches in their own. No, at least they make pressure on implementers to accept global FRAND rates under the threat of an injunction. But let me then pass through your last point, Gabrielle, these expectations, right? Because what I found in commenting this decision is that the arbitrators, the WTO arbitrators' reasoning bears similarities to WTO non-violation complaints. And we know that there is still a moratorium on such complaints under TRIPS Article 64, paragraph 2. As we all know, non-violation complaints allow challenges to measures that nullify or impair benefits accruing under the WTO agreements, even when no specific obligations are violated. Well, we have seen that the arbitrators, in this case, found that China anti-suit injunction policy violated TRIPS, Article 11, and other provisions, exactly because it frustrated the functioning of the systems of protection and enforcement of IP rights implemented by other countries, emphasizing, more importantly, that the policy by China fundamentally altered the negotiating position of SEP holders, and even more importantly, because it removes the main incentive for SEP implementers to negotiate with the patent holder a licensing contract on FRAND terms. This is language which is typical of non-violation complaints, right? This reasoning mirrors the essence of non-violation complaints, which, as you said, protects legitimate expectations about benefit parties should receive under WTO agreements. And this parallel becomes even more apparent when considering that the arbitrators focused on how China's measures impaired patent owners' practical ability to exercise patent rights abroad, right? Rather than directly eliminating those rights. And again, this approach, in my opinion, resembles how non-violation complaints address situations where WTO consistent measures nevertheless undermine expected benefits. And we know, as I said before, that there is still a moratorium in the TRIPS agreement for non-violation complaints. Let me just conclude with some, if I have time, policy implications, because in my opinion, the arbitrator's decisions also misunderstands the pro-competitive function that sometimes anti-suit injunctions have in preventing patent hold-up. When patent owners use the threat of multiple worldwide injunctions to oblige implementers into accepting disproportionately high licensing fees. And also, anti-suit injunctions are granted by UK courts, have been granted by US courts in Motorola, Microsoft versus Motorola. And in the UK, anti-suit injunctions have been around since the 15th century. So it's not really a new concept. Of course, not in SEP context, in other contexts. And also, Germany has issued anti-suit injunctions, as remembered by Professor Watan. So, to conclude, my opinion, this ruling may have the effect of constraining legitimate domestic policy choices on IP, and also create dangerous precedents for judicial overreach in WTO. It may indeed extend the impact well beyond the China case. This is, in my opinion, a judicial activism which raises questions about the proper limits of WTO adjudication and the balance between international IP coordination and national sovereignty over domestic IP regimes.
Thank
Sorry
you,
if I
Enrico.
exceeded a bit. Okay.
No, very rich exchange. I have dozens of questions. We had agreed that we would do a tour of the panelists to comment on each other before we go to questions for another 10, 12 minutes. I don't know whether I was going to ask Mark whether he wants to respond right away before I go to Jayashri and then back to Enrico. Mark, and I have a personal question. I hope I'm not abusing my role. Only one decision out of the 5 was recognized by the panel and upheld by the MPIA as decision that should be published, decision of general application. Usually we use this in WTO for laws. Why is it only 1 out of 5, and what's the difference? But please go ahead if you want to comment further on Jayashri or specifically on Enrico's comments.
Sure.
Please,
So
Mark.
I'll try to do both in as quick a amount of time as possible. I think the
3 minutes.
Oh, okay. Well, the short answer is that the logic is not terribly persuasive to me in terms of Chinese law, that only this case should be published. I think the same logic would extend to the other cases, except if you're looking at a case that was the first and therefore arguably precedential, but China is not a system of precedent. It's a system where cases have a pedagogic function and a guiding function that's slightly different from common law precedent. And on that basis, you would recognize more of these important ASI cases as requiring publication because they're of general application. The second thing I just wanted to briefly talk about is about the dangers that we've just heard about this decision in terms of ASIs or frustration being a guiding principle. I think we have to put this in a bit of a box. SEP cases are relatively few, and they're extremely important cases. They're also an area where the law is fairly harmonized. There's international standards bodies and local standards bodies that often reflect these international organizations. What we're ignoring here, and I think I haven't said it, and I think anybody else has said it, the reason these cases have appeared is that royalty rates determined by Chinese courts are much lower than European courts and certainly lower than US courts, which generally get the gold medal in the royalty rate Olympics. So for that reason, we're looking at an economic motivation that could really disappear if Chinese courts started making determinations that are more compatible with international standards. I think it was a conversing case. The rate was nearly 20 times higher in Germany compared to China. So I recognize that there is this doctrinal principle. It's new. It's a bit uncabined, but I'm not sure it will go as far as Enrico suggests. At least I hope not.
Thank you very much. I don't know whether, Enrico, you want to respond immediately on that. Otherwise, I'll ask Jayashri and then I'll go to you. Jayashri?
Thanks, Gabrielle. Thanks, Mark and Enrico, for a very, very interesting discussion so far. I just wanted to point out the India mailbox case on legitimate expectations. So in the India mailbox case, the panel said that In our view, and I'm citing this, in our view, good faith interpretation requires the protection of legitimate expectations derived from the protection of intellectual property rights provided for in the agreement. And then it cited other GATT precedents GATT precedents where the same principle was used. The Appellate Body in that case, because it went on appeal, said that the legitimate expectations of the parties to a treaty are reflected in the language of the treaty itself. The duty of a treaty interpreter is to examine the words of the treaty to determine the intentions of the parties. This should be done in accordance with the principles of treaty interpretation set out in Article 31 of the Vienna Convention. But these principles of interpretation neither require nor condone the imputation into a treaty of words that are not there, or the importation into a treaty of concepts that were not intended. I think this is very clear, and this is entirely with respect to the TRIPS agreement. So I leave it there.
Thank you, Jayashri. So if I understand, your conclusion is that there are no, in your view, reference to that in the TRIPS agreement, reference to frustration or anti-frustration, as you called it in your introduction speech. Enrico?
Yeah, I mean, I just follow up on what Professor Wattal said now. It seems that the appellate body in the mailbox case embraced a more textual interpretation rather than purposive interpretation of the agreement. In our case on anti-suit injunction, instead, it seems that arbitrators have embraced a very broad purposive interpretation of the TRIPS agreement, and therefore I think that the mailbox decision, appellate decision, clashes a bit, no, with what the arbitrators have said in our case. And to follow up to what Mark said before, yes, probably I've been too dramatic on the possible spillover effects of this ruling, but we will need to be patient just for a few months or a year, because we will see if this new anti-frustration rule will be considered and applied by the panel in the other case, which is now, as far as I understand, the panel has not been established yet, but it might be, and next year, 26, I don't know, we might have at some point the decision, and there we will see whether, you know, this anti-frustration rule will be again used to say, no, look, you cannot adopt global license front determinations considering predominantly sales of the patented products abroad in other jurisdictions. So I think in a few months next year we will know the exact extent of the impact of this decision. But then, if you allow me, Mark, just with reference to the, I have a question for the reference to the unwritten policy. You know that both the panel report and the arbitrator said, okay, no, this is a policy for sure, because we had like 5 anti-suit injunctions in less than 2 years. But as you know, there have been also a case where Chinese courts has refused the anti-suit injunction in Lenovo versus Nokia. And that was an argument adopted by China. Do you think it was a weak argument, or because, you know, even if I draw a parallel with compulsory licenses, and Professor Wattal knows that the Natco Bayer compulsory license was granted in 2012, but then a few months later 2 compulsory license applications were refused by Indian authorities, right? So can we have the same comparison here? So in Lenovo versus Nokia, Chinese courts did not grant the anti-suit injunction.
You know, very good question. Something I've been thinking about since the 2 or 3 years of that decision was made available. To me, this is a classic example of the Chinese maxim: you have a policy, I have a counter policy. And Lenovo versus Nokia, China made it clear that ASIs could be denied, and it was not such a necessarily a durable part of the Chinese legal system as perhaps the EU is trying to make out. That being said, it's clear that when you have 5 cases in a very short period of time, and you have very high-level officials saying this is the way to go to deal with SEP litigation and high royalty rates, and there are several cases coming from the UK, the US, etc. It's pretty clear that the weight of the government was behind the granting of anti-suit injunctions, and that's why I think we all easily, at least speaking for myself as a common law lawyer, we easily step into this view that we're looking for something like common law precedent under Article 63. That's not, I think, the reason that China publishes cases. They're publishing cases to give general guidance and instruction to the community at large, but not necessarily to be bound by them. And to me, that's still a kind of general application. And for that reason, it was worth bringing the case and mentioning that these cases could have gone forward. I really appreciate that China took steps to truncate ASI policy at that point in time, or at least decide we're not going to do any further until we get this resolved. That's also an unstated policy, but that seems to be what we can read from the actions.
Thank you very much. Unless, Jayashri, you wanted to say something quickly, 1 minute before I go to the participants. Please, Jayashri.
Thank you so much, Gabrielle, for giving me the floor again. I just wanted to point out that the UK submission to the MPIA as a third party, the UK says in its submission that they actually do not believe that 1.1 can be read in this way. So I would ask all those who are interested to look into the UK submission, where it says that the panel correctly understood the ordinary meaning of Article 1.1. It also correctly observed the context and so on. So this is in the addenda to the MPIA documents. Thank you.
Very interesting. So they do use ASI a lot, but they don't think the reasoning was the right one. I was going to give the floor to my colleague and friend Petros Mavroidis. Are you there, Petros? I understand you want to speak. Enrico, you want to speak also?
After Petros.
Ma
Okay,
no,
maybe
dai,
after
Enrico,
Petros.
vai tu, io aspetto.
No, just following up on what Professor Wattal said. I think the reason why the UK did not, endorse totally the EU is because they have granted the anti-suit injunctions, and also, as I said before, they want to attract litigation to the UK for establishing global fund rates. So there is a vested interest there.
Enrico, I think you meant not the US, but the EU. Because
Sorry,
the US
EU, sorry.
Yes. So, Petros.
No, I want to make
Please.
just one comment and ask a question. I'm sorry I'm not there, but I have to be in New York now. We teach this semester as usual. The comment I have is, I understand very much, and unfortunately the report does not, neither the panel nor the MPIA went into this direction in a comprehensive manner, let's say, is that there is this discussion about global fund, because global fund, of course, from a point of view of efficiency, this makes sense. But the question is, how on earth do we end up with global fund? Because prices are endogenous. You don't expect to have the same price chart. I was raised in Kerala, in India, in the south. You don't expect in Kerala and in the US to have the same prices. So our fund is different from the American fund. But one area where I think it is an interesting development, and maybe the 3 panelists will have something to say, is the Unified Patent Court in the European Union, where there is a discussion in the European Union, at least. Now, I understand this is sample bias because the EU belongs to the wealthy part of the world, but there is some discussion towards coming up with some sort of harmonized fund, at least. My question to so I would like the reaction of all three to this question. And my other question to all three is, there is one area where both panel and the MPIA report are in full agreement. And in that they characterize the ASI as not an enforcement action. And I was wondering, I said, my God, when we teach civil procedure here in my school, we got it all wrong, because this kind of stuff is supposed to be, I mean, the apotheosis of enforcement action. Now suddenly I hear from the WTO, this type of instruments are not enforcement actions. Fine, maybe the WTO knows better than 300 years of legal tradition in the US, but in this case, what on earth is the ASI? And how does it come under the TRIPS if it is not an enforcement action? And with this, I'll stop.
Thank you, Petros, for clever comments, but fascinating questions. And I see that Mark, Enrico, and I think Jayashree already want to answer your questions. Maybe we start with Enrico because he raised it first, then Mark, then Jayashree if you want, and other people, just raise your hand, please.
I don't want to monopolize the conversation, so I will let.
No, please.
Okay, so first point raised by Petros. Yes, I mean the argument which is brought by those who propose the global fundraise is that these technologies are global and the actors, the corporations are global, both patent owners and implementers, and therefore it makes sense to do that, to establish global fund rate. Also, the argument which is brought is that the implementers would like to just litigate nationally in order to delay the process. But this is an argument. But I really share your concern. Also consider the principle of territoriality of patents, which has as I said before, has been totally neglected by the arbitrator's ruling. With reference to the characterization of anti-suit injunction as not enforcement procedure, well, both the panel and the arbitrators basically have agreed that this is not a remedy, of course, which is asked by the IP owner. No, that's what that section of the TRIPS agreement is about. It's about injunctions. It's about damages. It's about destruction of counterfeit goods. So injunction, yes, of course, are enforcement measures, but anti-suit injunctions are the other side of the coin, and therefore are not included in that. And also because we need to understand what is really an anti-suit injunction, not just in SEP's context. According to many, it is a legitimate case management tool to protect the forum's jurisdiction. So, as such, should not be treated the same as damages, for example. I know it may appear a bit formalistic as an explanation, but I think this is what convinced both the panel and the arbitrators to agree on that.
Before I go to Gupta, the Secretary of the Permanent Mission, please, Mark. Do you want to add, please?
Yeah, I'm here. I just wanted to chime in on two aspects of Petros's excellent questions. One is one issue you didn't mention about an ASA not as an enforcement mechanism, and it concerns me, is that the TRIPS Article 41 at SEC have certain rule of law concepts built into it. Right to an independent judge, for example, right to a written decision. Some would say the right to independent counsel. If you and so yes. Okay.
Do you want to take a minute and I'll go to Jayashree?
I want to go ahead. Sorry.
I'll go to Jayashree and then I'll get back to you, And then we have question. Jayashree?
Yeah, I just want to address Petros's last question. Why can you not, why is it not, why is an ASI not an enforcement provision? Why did the panel say that and why did the MPIA agree? It's because the enforcement provisions in TRIPS are written in a way that it's about the right holder taking action against infringers. In the ASI case, it's about the implementer the implementer asking for an anti-suit injunction in order to settle FRAND rates, basically. So it's not an enforcement measure. None of the language in the enforcement section would really apply to such a case. And that's what the panel reasoned, and that is how it's really about settling of royalty rates and not about infringement as such. So this is how the panel reasoned, and I think they are right in that. So, yeah.
I'll go back to Mark, but I'm introducing a question, and then I'll go to Mark and the participant. It seems that often in the TRIPS, you see, Jayashree, you just gave an example. You say enforcement measures in TRIPS means the private holder enforcing its right, which is not usually the way in WTO single undertaking. The term is used. So the more I listen to experts for the last 2-3 weeks preparing that, the more I think, my God, TRIPS has all those specificities. They should have been mentioned because otherwise, remember the single undertaking. And my other question is that if you have international frame, a license internationally applicable, and then you have India who comes with an AASI, and then another country that come with an AAASI, how do you settle that? So I'll go to Mark, and then Gaurav. I see Jonathan Freed. So go ahead, Mark.
Okay. Well, first of all, most of the cases, if they involve a large company like a Qualcomm or a Nokia, whatever, most of them are settled. They're not part of multiple litigation. Sure, the litigation does appear. So the system. There's litigation. A lot of it is from patent assertion entities. They have a lower settlement rate. For the big companies, though, it's less the case. So it's not that broken a system, particularly when you consider the quantities of license agreements that are concluded and the amount that are concluded. I would say that one of the big issues here is that you have one country, China, which insists it's a developing country and at lower rates, and that other markets like Europe and the US insist that the values are higher. And that does create a bit of a disequilibrium. In terms of, I just want to step back a little bit on global FRAND, just to point out one other issue that wasn't raised, and I have an article that just came out this month before the European Intellectual Property Review, which is a difficulty in global cases, is that the concept of FRAND varies dramatically from country to country. What is FRAND? And actually in China, in most of the court cases, it's not fair, reasonable, and non-discriminatory. It's fair, reasonable, and or non-discriminatory. And the result has been that you get cases that focus only on fair or reasonable or non-discriminatory, or fair and reasonable, et cetera, et cetera. And that really sets China apart. And I would argue that they're not really adjudicating FRAND, they're adjudicating something else that's a little bit of a judicial creation. And for that reason, it is distinct from what is happening in most other, not all, but most other global markets.
Thank you, Mark. So I have 3 interventions hands. Enrico, can I ask you to be patient and you'll respond with the 3 panelists after? I have Gaurav Gupta from India, Jonathan Freed, Ruben, I don't see your family name, from the EU. I would suggest that the 3 of you raise your question. Ideally, you should, if you're not able to intervene orally, put it in the questions and answers. So the 3 of you could go ahead with your questions, and then I'll ask the 3 panelists to respond. Oh, Petros, you can come back, and Lou. Let's do a series of questions. We still have 20 minutes. So 5 questions, please. Gaurav Gupta. Gaurav, are you there or you don't want to? Well then, Jonathan Freed.
Hello, can you hear me?
Oh, yes, Gaurav, go ahead. Yes.
Yeah, thank you. Thank you for the floor. I was muted before that. So my question to panelists is that can they comment about the nature of the ASIs used by the Chinese court in terms of the extraterritorial applicability of the ASIs issued by the Chinese court as came out that in this particular dispute? And also, is there any precedent of other court jurisdiction in the world which also used where courts use these kind of extraterritorial application of similar decisions? Thank you.
Thank you very much. Jonathan Freed?
Well, let me start with thanks to you, Gabrielle, for pulling this together, and to all the panelists. Very rich and bringing a highly technical subject down to the level that amateurs can understand. So I'm very grateful for that. In that same spirit, however, let me ask, with the limited time, if we can get brief comments about what goes on down the street from the WTO. We're talking about intellectual property. WIPO owns the substantive rules and procedures surrounding them, codified in several treaties. What seems to be identified is some shortcomings in the underlying disciplines, which are largely decided by the intellectual property people. Tony hasn't intervened. We've lost Mario Matos, who has worked on both sides. He doesn't seem to have stayed with us, but I'd be grateful for some context on this for those in our participation list who are still working beyond the confines of the WTO to make a better organized intellectual property world. So I'll stop there. Thanks.
Thank you. I was going to go to Ruben from the EU Commission. Are you still with us?
Yes, I'm still here.
Please.
So thank you for the floor and for the interesting analysis of the case that we've been working on for a long time. I just wanted to come back to the point that Enrico raised concerning the territoriality of the patent rights, because in our reading, both the panel and the arbitrator actually took the territoriality of the patent rights as their starting point. And the panel then concluded that there is nothing actually there because it's only TRIPS only imposes the obligations on the member to actually take actions within its territory. The arbitrator went on the other side and said, no, actually, you should also not actually impact on the patent rights and their exercise in other territories, precisely because it is a territorial right. And this same element, I would say, would also be very important if one looks at setting worldwide rates, because there the same questions come up as to what would be the legal justification for a court in one member, let's say, for example, China, to determine binding rates for the patents in other jurisdictions. It's our view that there one would again run up against actually the boundaries of the territorial nature of patents and might be transgressing on that. So would be grateful also, and you could hear your views on that, and perhaps also from Ms. Vatal as one of the original negotiators of the TRIPS on how you see this unbalance between the global rate setting and the territoriality of the patents.
Thank you, Ruben. And the UK is said to have set up a few of those global. Myself, I don't understand how we can work in practice with AASI and AAASI, etc. I have Petros and Lou.
I'll be very brief. I mean, of course, I can read the TRIPS agreement and see that ASI does not feature among enforcement actions. But if we want to be intellectually honest, the first time we have anti-suit injunctions, the concept exists from the 15th century. It is 2012, the Motorola case. 2012 is 30 years after JS renegotiated the TRIPS agreement. Shouldn't the panel, at the very least, ask the question, now I have in front of me new fact and I have a new practice. Should I rethink maybe, as I did in other cases, example, exhaustible natural resources? Should I rethink the way I understand enforcement actions? What startled me is not that the S panels usually do, and that's what upsets me with the WTO, think that words are acontextual. That's fine, I get used to it. What startled me is that we deal with in an area where things change from one day to the other, and no one had the decency to say, stop, things have changed. Does this thing make sense? I'm not saying panel to become lawmakers, at least acknowledge the change. This is what startled me.
Thank you. Lou, are you still there?
No,
Lou?
no, sorry, it was my mistake by my fatty finger. No problem. Go ahead.
Okay. All right. Thank you. So I don't see any other questions unless Stella indicates. I suggest that we go to Enrico and then Mark and then Jayashri, and we'll see whether we have time for more questions. So Enrico.
Okay, I will be very.
You answer whatever you want.
Yeah, I will be very quick on two issues that have been raised in the latest interventions. First, the categorization of anti-suit injunctions as non-enforcement measures. Another example which could be made of an action which does not fall within that section is when alleged infringers ask the court to declare that they are not infringers. Non-infringement declaration, let's say, right? That would be still a measure asked by alleged infringer, but not by IP owners. So it would fall outside the TRIPS agreement, the section there. And so it would be similar to the anti-suit injunction measure. Then on the point raised by Ruben, of course, there are also extraterritoriality issues, problems in the global FRAND licensing approach adopted, for example, by the UK. And also China, as I said, adopts started a few years ago adopting global FRAND rates. But I think there is a major difference between the two. Not only that the UK courts, they usually establish a higher fees rather than lower like the Chinese, but also that in Unwired Planet, in subsequent cases in the UK, most of the sales occurred outside the UK. Just a very few percentage points of sales occurred in the UK. That's why some commentators have labeled this approach by UK courts as a post-imperialist judicial practice in order to attract litigation in the UK. It seems to me, as far as I understand, instead, that in China, there is not the same proportion of sales abroad rather than in the UK. Of course, I think this is the main difference between the two. But I agree with you, Ruben, that global license FRAND approaches raise, of course, extraterritoriality issues. But in my opinion, we need to then look at how much has been sold of infringing products in the the country which adjudicates, that dispute. I think this is the most important aspect. I just wanted to clarify these issues.
Thank you. Mark?
Sure, I'll pick up two of the issues that were raised. One is this notion of the extraterritoriality of FRAND. I think we have to recognize that FRAND is a very unharmonized concept. We're dealing with not just the English language, but many other languages in the world. FRAND is, of course, an English term, many other legal cultures, and widely varying translations of FRAND. I mentioned earlier that FRAND in Chinese, I calculated over 600 potential translations of FRAND into Chinese based on the different words that are used, several of which I would say a dozen to 2 dozen are extremely meaningful, such as replacing an and with an or, so that FRAND is no longer a unified concept. And this was picked up by Justice Burse in the UK, where he noticed just from, I guess, the translations that Chinese were sometimes just applying fair or reasonable, not looking at it as an integrated concept. So I'm not terribly optimistic on the possibility of a unified concept for FRAND unless there's some agreement at the standard setting level. And China has particularly been aggressive in carving out its own unique approaches, which I think make it particularly ill-disposed to reach global rate determinations when their translation by FRAND is necessarily quite different from the translations and the original meaning of FRAND. But that's just kind of a heads up on a potential issue. In terms of WIPO and Jonathan's comment, I think we have to recognize, and several people have already pointed this out, that the intellectual property treaties predate the GATT, they predate the WTO, and particularly at a time when national treatment and MFN treatment under attack, such as from President Trump here in Washington, you have these concepts that predated the WTO in terms of IP issues, and they actually hold some promise. I just don't know, frankly, given the paucity of cases brought against China or IP cases generally under the TRIPS agreement, whether the WTO is the optimal venue for them. Transparency is quite different in the TRIPS agreement than in other WTO contexts. It's important for civil cases because civil cases are the primary means of enforcing IP is absolutely critical. If you're going to have to look at each one on its own merits about whether cases should be disclosed, it's going to be very hard to evaluate compliance and non-compliance with any WTO requirement, let alone the rather complex one of SEPs and FRAND. So that's really an institutional type concern. Maybe the panel or the arbitrators overreached a bit, but they are reaching to an important question, which is this kind of lack of harmonization and the difficulties at reaching global resolution of disputes.
Thank you, Mark. Jayashri, do you want to add something and explain how those international agreements on prices are possible with the ASI and AASI and AAASI in real life? I'd like to understand how this can happen.
Thanks, Gabrielle. I actually want to take up all the questions one by one, if I may. First, coming to your question on the WTO was born out of a single undertaking, so why is TRIPS so different? I mean, frankly, it is a single undertaking because TRIPS was difficult to swallow. Without TRIPS, there would be no Uruguay round results. There would have been nothing. So that TRIPS is different. Is got to be accepted. And you have to read Matthew Kennedy's book, as I keep saying, on dispute settlement, where he shows why TRIPS is different and why GATT concepts cannot be applied to TRIPS. Anyway, let's go to Gaurav. Gaurav, your question on the nature of ASIs, are they not extraterritorial? And has any other court done it? Yes, lots of courts have done it, as we've been saying in the discussion. And yes, that ASIs are extraterritorial. They existed not in the context of SEPs, not in the context of patents, but in other contexts. They did exist at the time of the TRIPS negotiations. But nobody really thought about putting it in or putting any language in this. Now, would WIPO be the right forum to do something about it? Do we not need to streamline treaties? Do we not need to amend, and do something about this new issue? Let me just tell you, this is not, as I mentioned very briefly in my opening remarks, this is not just about IP or patent law. It's also about contract law. It's also about competition law. So it's not just an IP issue. And settling what FRAND is and whether there should be a global FRAND. Obviously, that's the ideal situation. The EU, and perhaps Ruben could enlighten us on where we are on this. The regulation, the draft regulation that the EU wanted to bring in, it then withdrew because these are not easy issues. there are very powerful parties on both sides, SEP holders and implementers. Both sides are very powerful. So this is something they would like to not have any interference on. That's my reading, but I may be wrong on this. I'm not really the expert on SEPs. On territoriality, Ruben, to come back to your question about Article 4 bis of Paris, and yes, you are absolutely right that the panel and the MPIA looked at the same issue from different angles, and one reads territoriality as saying that you the 4 bis really doesn't apply to this, and the other reads territoriality to say that you can't actually do this. But you know, so many courts now are involved in ASIs and AASIs. To say that 4 bis comes in the way would not really, in my view, I don't think it would hold, you know, in this particular context of FRAND. If you read the most authentic interpretation of the Paris Convention, which is written by Bodenhausen, you know, the first, Director General of what was then WIPO, you know, clearly he looks at 4 bis, and the language itself is about patents are granted, are applied for and granted independently in each jurisdiction. And if there is an invalidation of a patent in one jurisdiction, it will not affect the standing of that or the status of that patent in any other jurisdiction of Paris Union countries, right? That's the interpretation that we all grew up with, and that's the interpretation that we negotiators had at the time of the TRIPS negotiations. Now, if you want to read more into the independence of patents to say that ASIs are no longer, you know, they are extraterritorial, then you know, what are you going to do? Because all courts around the world are issuing ASIs and AASIs. So I think that partly also tackles what Petros said about FRAND, because FRAND, in my view, is not a pure TRIPS issue. Look at other issues. You know, TRIPS has been silent on other things which members have been very agitated about vis-a-vis China, which is the forced technology transfer. There was a case brought on forced technology transfer. TRIPS is silent on that, and that case was never pursued. So yes, TRIPS needs to be amended, needs to be brought up to date. Is the WTO the right forum? How are we going to do this? I mean, these are all questions which are up in the air. Yeah, I'll stop there. Thank you.
Thank you. So I don't see any other questions. I don't know whether my two other panelists want to say a last word in a few seconds. If not, I will say thank you to you, pass the microphone to my boss, to Lou, and thank him and Alejandro for trusting me to handle this moderation. Lou, I say goodbye and I leave it to you.
Thank you, Gabrielle, and we wish you to thank you for your able moderation, and that's clear proof that why Alex suggests that we give you this job, and not only that you are able to do that, but also that to how to correct your illusion that retirement would be easy and happy. This is not the case for FMG members, and of course I want to join you in thank you the whole panel for their really excellent presentations. Of course, this is a much complicated case, and as Jeffrey said, that there are many things high in the air, which goes beyond the case itself or the trips and so on and so forth. So that's why that this 1.5 hours could not do how to say respect to such a kind of various aspects of this case. But this is an ongoing thing that I think. This is also reminds us that we can only try our best to cover probably the most substantial part of the panels. And the last word I want to say for this series, of course, which I forgot to say at the beginning, we will only tackle our decoding session. Will only try to tackle the the cases with final rulings either by the panel process or by the MPIA. For those kind of ongoing or to be appealed, or for whatever reason suspended appeal in void, we try to avoid them. So with that, I thank you all for joining us, and especially to the big audience who are still with us. We had 100 and we still have 70 also with us. Thanks a lot for supporting our work. We look forward to your engagement in the future. Thanks. Bye-bye.
Thank you to the great panelists.